far as take the part.
Yeah.
I'll walk with you.
You don't have to.
Sue wants me to.
Yeah. I'll move over. I'm okay.
You're ready.
Thank you so much, ladies and gentlemen, and welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution, and I'm thrilled to welcome you tonight for our conversation with Justice John Paul Stevens, one of only 2 public appearances that he's making in connection with his new book. We're also thrilled to have the chance to interview him for C-SPAN's Book TV, which I'll be doing later this month. And then in October, Justice Stevens will be joining the National Constitution Center and the Ford Presidential Library for a special symposium on the constitutional legacy of President Ford, and we're very excited about that. The National Constitution Center, as those of you who have been here before know, is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And to achieve that inspiring mission, we have 3 goals. We're the Museum of We the People, and starting next fall, we'll be displaying one of the 12 original copies of the Bill of Rights. We are a center for civic education, and we're building the best interactive constitution on the web with nonpartisan constitutional content for students across America. And we are America's town hall, the one place in this polarized time when citizens of different perspectives can come together and hear the best arguments on all sides of the constitutional debates that are riveting the country and make up their own minds. I cannot imagine a person, a justice, who better embodies this nonpartisan tradition than Justice John Paul Stevens. This man is a living legend. He was nominated to the Supreme Court in 1975. He retired in 2010, making him the 2nd longest justice in the history of the court. But his personal story, as you'll hear tonight, is riveting. He was born in 1920. Just last weekend, he celebrated his 94th birthday, and tomorrow he's going to further celebrate by playing a good game of tennis. So we don't want to keep him too long tonight. He remembers, as I learned when I had the privilege of interviewing him a few years ago for the New York Times Magazine, that as a boy, he met in the Stevens Hotel, which his father owned and which was now the Chicago Hilton. He met Amelia Earhart, who asked him why he was staying up so late after school. He went on to become a path-breaking code breaker in World War II, where he helped break the code that led to the shooting down of a Japanese admiral, which was crucial in the war effort. He was at the top of his class at the University of Chicago and Northwestern. He clerked for the Supreme Court, and during his 39-year tenure on the Supreme Court, the 2nd longest serving justice in the history of the court, he developed a reputation for emphasizing the importance of nonpartisanship and governmental neutrality. Justice Stevens believes that government should be neutral when it acts, and that's why he was such a fiery opponent on the bench of things like partisan gerrymandering, and he insisted on neutrality in all government actions. The excitement of this new book, as you'll hear tonight, is that he proposes 6 constitutional amendments, many of which emphasize the importance of government neutrality when it comes to campaign finance reform, or banning partisan gerrymandering, or abandoning the doctrine of sovereign immunity that prevents states from being sued. And even in his comments on gun control and the death penalty, neutrality and nonpartisanship is his watchword. So it is an absolute thrill to have him. Interviewing him tonight, we are honored and delighted to have Brooke Gladstone, the co-host and managing editor of WNYC's On the Media. And tonight's discussion is a co-production of WNYC and our good friends at WHYY, the superb NPR station across the street. Brooke Gladstone joined National Public Radio as an editor of Weekend Edition with Scott Simon. She went on to be a senior editor, and she's now known as the first among NPR's media reporters and editors, and that's why we're so lucky that she is here tonight. I ask you to turn off your cell phones. Also, at the end of the discussion, please don't leave your seats until Justice Stevens leaves. Please write your questions down on cards, which our great town hall director, Robin, will collect and bring up to the stage. Please turn off your cell phones, which is a good reminder. And now, ladies and gentlemen, please join me in welcoming the great Justice John Paul Stevens.
Thank you.
Thank you, Jeffrey. I thought you were coming here. Thank you.
This is an honor. You guys can hear okay? All right. Well, let's get to it. We heard some of your background. I'm wondering, though, if any of your pre-judge experiences when you were a kid helped shape what became your legislative perspective later. For instance, you saw the repeal of prohibition. Did that have an impact on how you saw the rule of law?
Well, that's an interesting question. I have always, ever since 1932, I guess, thought that the experiment with prohibition was a profound mistake. Not necessarily because drinking is a great idea, but it did seem to me that that whole era created more problems than it solved. And I've had the same thoughts about the regulation of certain marijuana, for example, that creates an awful lot of problems and doesn't seem to be accomplishing a great deal.
You also saw, when you were a kid, your father convicted of embezzlement. The Illinois Supreme Court later declared that this conviction was not based on a scintilla of evidence. Did that shape also your view of the American justice system?
No, I don't really think it did. I think that that was a terrible miscarriage of justice, and I guess it taught me the lesson that the system can misfire. It was a clearly incorrect decision, but it never, I don't know exactly how to say it, but I don't attach that example as having a profound impact on my later thinking.
Jeffrey Toobin in The New Yorker once characterized you as an unlikely liberal icon. I guess because you were a conservative Republican when you joined the court, appointed by Gerald Ford. I think you were supposed to write, which I mean in both senses, the sort of what was considered to be a liberal bias on the court. That's not what happened. It surprised some people. Did it surprise you?
No, I don't know exactly how to explain it, but I did think that a certain number of decisions that had been made by the Warren Court were incorrect, and I think some of those changed while I was on the court, and I had something to do with some of those. But I never have felt that you can classify a court simply as liberal or conservative. There's too many different cases that come before the court that require individual attention and individual study, and I don't really think any member of the court just automatically decides on the basis of a broad point of view or something like that.
You don't feel that way even now, when the court seems to be stunningly polarized. I mean, I know this isn't unprecedented, but it does seem to be strange how some decisions are made, and we'll get to those in a little while.
Well, I think they make a fair number of decisions that I disagree with, but I think they're doing their best as they move along, and I wouldn't try to characterize all of the decisions in one category. There are too many different issues.
You said that when you came on the court, there were some decisions that had been made prior to your coming that you disagreed with. And I wonder, this hasn't come up in any articles and we didn't discuss it before, but were there any cases when you were a brand new justice that sort of said to you, okay, that's how this place works, or forced you to reconsider an issue you thought you already understood? Or was there a formative early case or two that helped set the stage for later?
Well, it's a question you can't answer in a very simple way.
You can answer it in a complicated way. I'm from public radio.
I had been a law clerk for years before, and I'd spent 5 years on the Court of Appeals, and so I had some familiarity with the run of the business that goes through the court. And I had learned that you got to take each case by itself and decide what to do in the particular case. And sometimes you come out in a position that might be described as liberal or conservative, but it's not part of an overall program. It's a case-by-case job, and it's still true of the members of the court today. I think in some areas, like campaign finance, for example, I think they've made a series of incorrect decisions. But overall, they're taking them one at a time, and I think they're doing the best they can.
I'm going to just give this one more go. I just would I would love to sort of get into your head about an early case, if there was one, that, just threw you or just made you think about either your process or certain principles or just something that I think that anybody who cares about the court really wants to know what it's like to be a justice. What you do has such far-reaching implications, which is why I'm just wondering if there is some sort of before we get into the actual cases that are high profile, which we will in a moment, if there was just something maybe not so high profile that kind of just made you go, oh, wow.
Well, there isn't one case that I can point to say that
I should have asked you beforehand.
Turned around everything that I did, but there were a number of difficult cases, and I do remember one that I think I voted incorrectly in, which was the Texas death case, which was heard at my first year on the term. We, in the plurality opinions that Justice Stewart and Justice Powell and I wrote, basically decided that the death penalty would be permitted if they followed adequate procedures. And we differentiated between state statutes that imposed a mandatory death penalty on the one hand and those that imposed penalties after having certain procedural protections that are involved in the sentencing hearing. And in the Texas case, we held that was a permissible statute.
Because they had adhered to some of these procedures that you had prescribed.
Well, the thing about the Texas statute is that they did have an instruction required by the statute that made it the equivalent of a mandatory death penalty. And I think I failed to appreciate the significance of that instruction and incorrectly concluded that it belonged in the permissible rather than the impermissible category, and I think I got that wrong. But I do think that there are dogs in here. But anyway, that's an example of a case I think I voted on incorrectly.
Because so in the Texas case, you knew that they had a mandatory death penalty, which you didn't support, but you thought that they were adhering to certain procedures that they didn't adhere to?
I didn't think erroneously, and I disagreed with my law clerk on this, who's now a professor at the University of Virginia Law School, George Rutherford. I didn't think the instruction really was the equivalent of a mandatory death penalty, and that's why I voted the way I did. But on reflection, I was persuaded that I got it wrong.
Well, this is a good segue to your book, 6 Amendments, How and Why We Should Change the Constitution. Jeffrey Toobin, who I mentioned in The New Yorker, said that an alternate title could be 6 Times I Was Right in the First Place. Is that fair?
Let me think about it. Well, and not entirely fair, because I didn't dissent on the death penalties, but as a matter of policy, unlike constitutional law, I do think the death penalty is an unwise provision of our law, and the states would be better off without the death penalty. But I don't think that means I got it wrong in deciding what the Constitution required. But I do think that if one just looks at the cost benefits involved in capital punishment litigation, the costs are tremendous, and the benefits are really almost trivial when you compare the death penalty with the possibility of imprisonment for life without possibility of parole, and the fact that the real justification for capital punishment is retribution, an eye for an eye, for a tooth sort of thing. But the death penalty jurisprudence that has developed prevents states from imposing punishment that is harmful, painful,
Cruel and unusual.
That's right. They prohibit the one sensible justification for a death penalty, which is trying to have retribution to the defendant that's comparable to what he did to one of his victims. You just can't do that. And then, of course, at the bottom of the pile is the fact there's a very real risk, as DNA evidence has demonstrated, of making a mistake from time to time. And there may well be somebody who was not guilty who would be executed, which would be a terrible thing. You cannot really justify taking that kind of risk.
So the death penalty is one of the 6 issues about which you would change the Constitution.
Yes.
And what do you propose?
Well, I have a draft of an amendment in the book. It just said that I forget the exact wording, that the Constitution prohibits cruel and unusual punishment, such as the infliction of the death penalty, something like that.
Mm-hmm, mm-hmm.
Yeah.
And why do you need a constitutional amendment to do that?
Well, you may not, because the states are facing the issue more frequently, and I think over time the states may well take steps on their own to abolish the death penalty. But I do think that as long as it does more harm than good, I think it diminishes our stature in foreign countries, for example. They're unwilling to extradite people as long as they're, in some situations, as long as they're subject to capital punishment. And I don't think it does any real good. It cannot be accomplished elsewhere, and it's a terrible waste of money. It's an awful lot of money is spent on capital litigation.
But as a constitutional issue, again, this all seems to boil down to what is maybe the principal change in the book, which is the one you begin with, which is the anti-commandeering rule, which seems to release state officials from the obligation to enforce federal laws they don't like. The death penalty, or almost anything else you propose, fundamentally comes down to we need a stronger central authority in order to make changes that you think would be beneficial and strengthen the democracy across the board. So let's begin with the anti-commandeering rule. Are you looking for a constitutional change there?
Yes, that's the first one that I propose, and partly because I think the significance of the rule is generally not recognized. The example that I use in the book is the fact that in preparing background checks for as a
gun ownership,
purchasing a firearm, the federal system cannot compel states to follow their procedures on reporting exactly what information should go into the background check. And it seems to me it's just a sort of a simple thing, but there surely should be power in the central government to have a uniform rule that must be obeyed by all of the reporting jurisdictions. And I think that it has other similar applications in trying to locate missing children in different states and so forth and so on.
But what does the law say? Does the law say we have these federal rules, but you state officials, you don't have to follow them if you don't like them?
Well, if they obey their own state government in deciding whether or not to follow a particular federal rule, which the classic example that I discussed at some length in the chapter is administering a national draft when you a selective service system. When you're raising an army, it makes eminent sense to make use of state officials in many aspects of the selective service rules. And they did that during World War II and World War I. And it should be continued. It should be permissible, as I should say. But under the case that I discussed at some length, there is a problem.
And the example that you just gave about the failure of states to coordinate or even carry out background checks create a situation where you feel guns pose a greater danger. You also propose as one of your 6 amendments a change in the way the Second Amendment is interpreted or the way it's written? Or what would you do to our right to bear arms?
Well, I propose a slight change in the wording, which I think will make clear the intention will make the amendment have the meaning that the original drafters of the amendment intended to have. Namely, it was intended to protect militias from being taken over by the federal government during the early period of our system. There was a fear that the federal government would be too strong, and one of the things it was worried about was taking over state militias, which would mean disarming them. And I think that all I've done is suggest that the right to bear arms should receive constitutional protection, not just legislative protection, only in connection with preserving militia service. Yeah.
But with regard to legislative protection, that could still be changed state by state by state.
Yes, yes.
So ultimately, even if there were a constitutional amendment to narrow the interpretation of our right to bear arms as it's currently seen to on Fox to be defined, that it wouldn't make any difference in the states where perhaps it matters most.
It probably would not make much difference immediately, but it would, in the long run, let the final decisions be made by legislatures rather than the judges. I don't think that the final decision on firearms policy should be made by federal judges. I think it should be made by legislatures, and there's obviously a competitive market and ideas on the debates there that could go on. And perhaps in today's society it wouldn't make any difference whatsoever. But it would free the country to our state legislatures and national legislature to make the decision they think are the most wise.
Well, let me depart for a moment from the 6 changes in the book and ask you about something you just raised, which is legislating from the bench. Anybody who watches these things knows that when there's a liberal decision like Roe v. Wade, then the conservatives say they're legislating from the bench. And when there's a decision like Citizens United or the gun decisions, that the D.C. gun case and so on, that seems to be conservative legislating from the bench. Do you think one side or the other is more guilty of legislating from the bench? Do you consider those examples that I gave to actually be legislating from the bench?
Well, the term legislating from the bench describes judges making decisions that legislatures should make. Now, in the abortion case is perhaps the simplest example. Judges don't decide whether or not they should have certain abortion laws. The judges have decided whether a woman has a constitutional right to make a change in her own life. And the question is whether the legislation is permissible under the Constitution, which has a substantive component protecting an individual's liberty to make very profound decisions. And in my judgment, the opinion in Roe against Wade was kind of not as clear an opinion as it should be. Justice Stewart wrote in a separate opinion which very succinctly stated that the right to make decisions of that importance to the individual is an aspect of liberty that is protected by the Constitution.
Under what amendment?
Pardon
Fourth?
me?
I mean, which amendment?
For the Due Process Clause of the 14th Amendment. Mm-hmm. And it was not legislating from the bench. It was holding that the Constitution prohibited certain legislation by state legislatures.
Well, maybe the argument was, as you say, the initial decision wasn't written very well, talking about this penumbra of privacy, the sort of fuzzy zone of privacy. It's easy for people who are opposed to abortion to shoot holes in that original language, but you feel it was repaired by Justice Souter?
By Justice...
it was repaired in later language was clearer?
Well, let me just clarify one thing. The language about the penumbras in the Constitution was in Griswold against Connecticut, which is the case that held that the state of Connecticut could not outlaw the purchase of contraceptive. And there, Justice Douglas wrote this opinion about penumbras and so forth that created a so-called right to privacy. But again, there was separate writing in that case by Byron White, who said the real question is whether this is an infringement of the liberty protected by the 14th Amendment. And a great deal of damage to the law was done by an unfortunately poorly written opinion talking about privacy when they should have just concentrated on liberty. And I think the right to have access to contraceptives is certainly an aspect of liberty that one can understand as being entitled to constitutional protection. It is a similar aspect of liberty involved in the decisions to whether or not to bear a child.
Let's get back to the 6 amendments and go directly to one of my personal favorites, which is to do something about gerrymandering, which I think most people feel is largely responsible for the kind of anti-democratic gridlock that we have in Washington. What do you propose the court do about that?
Well, I propose that we amend the Constitution to make it perfectly clear that the courts have the same power to prohibit political gerrymandering that they have to prohibit racial gerrymandering. It's been established law for years that legislatures do not have the power to design grotesque districts in a way that makes it impossible, or makes it virtually impossible for racial minorities to elect representatives of their own choice. The rules that implement that rule, the prohibition against racial gerrymandering, can be applied equally to gerrymandering that's designed to perpetuate the strength of a political power. And there are a bunch of maps in my book that illustrate how easy it is to recognize a gerrymander when you see one.
Is it?
And this is a case that fits squarely into Potter Stewart's famous line about "I know it when I see it," when he was talking about
they are kind of obscene.
Yeah.
But I have to ask you this question. The chance of this one being raised, brought before the bench, and legislated, I mean, there's such widespread entrenched interest in maintaining this skewed system.
Well, that's certainly true, but in the long run, things have a way of working out in the way that makes the most sense. And I agree, I recognize that maybe I'm an idealist or something like that, but if people work to change the rules that allow gerrymandering to persist, it can be done.
While we're at it, can you get rid of the primary system?
Pardon me?
The primary system, really, it's become, now we have so many representatives that represent only people who vote in primaries, who tend to hold much more extreme and unbending positions than, that. In other words, the polls suggest, and I'm not a huge fan of polls, but the polls suggest that the representatives in Congress are not actually representing the majority, taken as a whole, are not representing American opinion as a whole, because they are responding almost entirely to primary voters, which is a very specific population. I mean, if all of this is really about strengthening the democracy, I really think you should do something about that, Justice.
Well, just make one observation on that point. One of the consequences of gerrymandering is to make the primary election more important than the general election, because the political parties will dictate who's going to win the election. And that has the effect of making parties more doctrinaire and less open to compromise. Whereas if the principal election is a contest between the two parties, I think you would have less of a gridlock than you have now.
Now on to Citizens United, which is on, I think, everybody's mind all the time. It was decided in 2010. It opened the floodgates to corporate money. Right, like money hasn't always had a huge impact on politics, but now it's nearly unrestricted, and the court's ruling suggests that we shouldn't even feel conflicted about that. Now, you noted in an earlier case that a democracy cannot function effectively when its constituent members believe laws are being bought and sold. And in your Citizens United dissent, you bluntly said that the majority's decision was a rejection of common sense.
Well, I think it was quite wrong. But I do think it took me some 80 pages, I guess, to say that, and I don't want to take 80 pages of your time tonight. But I do think, and I make this point in this chapter in the book, that there was precedent for much of what the court did in that case and has been doing in recent cases. And I think the really critical error that underlies much of this development of the law goes back to the 1976 case of Buckley against Vallejo, in which the court basically held that neither state legislatures nor Congress can impose limitations on the expenditures that candidates and their supporters can make. And I think that is a critical mistake that's been in the law since 1976, and that's a mistake that I think really can be corrected only by a constitutional amendment. I don't think, because the doctrine is so well entrenched.
But there's also that principle that corporations should be afforded the same First Amendment rights as citizens. I think that you may have observed somewhat snarkily that if the justices are so worried about corporations not having a strong enough voice, maybe they should give them the vote.
Well, the interesting thing is that it's not just the corporations, but the money that floods into the election is not necessarily corporate money, but it's often money provided by non-residents who are not eligible to vote in the particular jurisdiction.
And that's crucial, because Roberts said in his decision the most fundamental thing we're protecting here is the right for people to pick their own representatives. And you noted that these people aren't picking their own representatives; they're picking their representatives in states thousands of miles away.
That's exactly right. The first sentence of his opinion creates the impression that everybody has the same right to affect the elections in every part of the country. But you vote on a state-by-state basis, and although you may have an interest in the outcome in other states, your right to vote is limited to your own jurisdiction. And the objection to corporate excessive influence really has the same application to non-residents who have lots of money to spend trying to create influence in different parts of the country.
Which, and this is outside the specific purview, maybe it isn't actually. You weren't sitting on the court in the last couple of months when the McCutcheon case came down, which basically did for individuals what Citizens United did to corporations, unions, and
Yes,
big umbrella groups, that it lifted basically the limits of how much an individual could support a candidate. You didn't need the sort of double blind of a PAC. You can still hide your identity, which the court said while you were sitting on it, and even more recently in the McCutcheon case. How about ending anonymity? But nobody wants to do that. The court says we're ready, we're fine with ending anonymity, and legislators won't pass it, which I think is crucial. But I'm not interviewing myself. So in the McCutcheon case, They made the observation that they didn't see any indication that money was a corrupting influence in politics, which seemed extraordinary. What was your view when you read that?
Oh, I'm sorry, I'm not sure. I'm not sure I have the question.
Well, in the McCutcheon case,
Yeah.
the majority made the observation that there wasn't enough evidence to support the idea that money, contributions contributed by a few, corrupted the political process.
Well, I think the problem here is with the word corruption, because the court has treated campaign finance litigation as though these laws are principally designed to prevent corruption or the appearance of corruption. But the real justification for regulating campaigns, like any other contest, like litigation, is fair procedure. You want the different contestants in an election contest should have an equal opportunity to make their case to the people who are going to decide the answer, namely voters. So the real justification for rules in this area of the law is not just preventing corruption. The bribery laws take care of that. It's the real justification is having rules that allow a fair opportunity for competing candidates to make their case to the public.
Right. I think that the decision said if you could prove quid pro quo, then you had corruption.
Yeah.
Anything less than that, the fact that you can buy your way to sit next to a representative or a senator or a president in long private meetings, that that you can ensure the election of somebody with, one man basically supported Newt Gingrich's campaign last time around. And maybe just a couple of brothers will be largely supporting, it isn't, the volume of money is so unequal right now on both sides. It's not that there's not a huge amount of money going into the Democratic side, but it's more public. It comes from more individuals. I don't know.
And of course, I think most politicians would agree that spending as much time as they spend raising money is not the best use of their time as far as the public is concerned.
What was the worst decision the court made while you were there?
Well, I can't at the top of my head
Take your time.
say, but I'll tell you one that it might be worth an explanation. I wrote the opinion for the court in the case upholding the voter ID requirements in Indiana, I think the case was. And I think the decision was correct on the case, and not because I think voter ID are a great idea, but I think in the case before us, the plaintiffs failed to prove that the voter ID rules would have the adverse impact on the electorate that has generally been assumed later on. I think they did not prove their case. I think it's a case that they had an excellent trial judge who came to that conclusion. The record really didn't support the allegations. On the Court of Appeals, a very fine Court of Appeals judge, Dick Posner, wrote the opinion reaching the same conclusion. And I wrote the opinion on the Court of Appeals, again concluding that the voter ID requirements did not, in fact, have they did not prove that they had the adverse impact on minorities that is generally assumed to be the case now. And I think Justice Souter wrote a very persuasive dissent which indicated why that is the right conclusion. But I was persuaded at the time, and I think that Judge Posner was also, that on the record before us, those conclusions had not been proved. But I think that it's an unfortunate decision because I think it is interpreted as those of us who were in the majority concluding that voter IDs are a good idea, which is not the case at all. I don't think they're necessarily a good idea, and I'm not really persuaded they're necessary. but they are a permissible method of determining the eligibility of people to vote. And I think the statutes, the case before us, failed to prove the contrary. So I've always been unhappy.
So this is a decision that you personally regret that you had to make based on the case that was being brought before you.
That's exactly right. It's very, very much like the case I mentioned earlier.
The death penalty case.
Well, no, the marijuana case that I was going to mention is that I also wrote the opinion which upheld the power of Congress to enforce the marijuana prohibition against growing marijuana against the people out in California who had their own plot of marijuana and needed it for health reasons. But the question was not whether marijuana was a wise or good thing to do. The question was one of federal power. And I thought the federal government had the power that was at stake in that case, but I was very unhappy about the opinion I felt I had to write. And there's a vast difference between doing what you think the law requires and doing what you'd like to do if you were the guy running the legislature.
I guess that's another good segue to one of maybe the last of the 6 amendments, which is related to sovereign immunity.
Yes.
Isn't that connected to the anti-commandeering rule?
Well, they're both sovereign immunity and the anti-commandeering rule are the product of an exaggerated interest in protecting states' rights. And the chapter on sovereign immunity is really, I think it's really an important chapter because I think I fairly demonstrate that that doctrine is a byproduct of the emphasis on protecting the right of the states to discriminate against African Americans during the period in Reconstruction. And there's a relationship there that I don't think has been recognized, and it should be. And certainly, I'm just looking at the merits of the element rule. To have a rule that Congress has passed several statutes saying that state institutions must obey copyright laws, trademark laws, and other intellectual property laws, and the court has adopted a rule that state institutions have an immunity that is not available to private institutions. State hospitals don't have to obey certain rules, certain federal rules that private hospitals do. State universities can infringe patents and not be liable, whereas private universities cannot. There's a certain absurdity in the sovereign immunity jurisprudence that I urge you to read the chapter on and see if you don't agree with me.
I got some questions here.
Okay.
And one of them, and I'll probably pronounce his name wrong, is from Bill Raich. It relates to Bush v. Gore, which is something I wanted to ask you anyway. In your dissent in the case of Bush v. Gore, this is when the court decided to intervene in the contested vote count in the 2000 election. You wrote, "Time will one day heal the wound to that confidence that will be inflicted by today's decision. One thing, however, is certain. Although we may never know with complete certainty the identity of the winner of this year's presidential election, the identity of the loser is perfectly clear. It is the nation's confidence in the judge as an impartial guardian of the rule of law." Bill asked, was there any concern among the justices that Bush v. Gore would make the court appear overly partisan and diminish the reputation for fairness and even-handedness that it had enjoyed?
I'm not sure I have the question, to be honest.
I'm speeding through it. Do you think, in fact, that confidence in the court was wounded by Bush v. Gore?
Yes.
And do you think that
yes,
enough time has elapsed to heal that wound?
Well,
they say no. I guess you don't have to answer that one. But
again, there are two parts to the question. First, was the confidence in the court harmed by the decision? The answer is yes, it really was. I think there has been time, and perhaps enough time has passed to heal the wound, but I'm not sure it's been done.
And do you think it's because of subsequent decisions that seem just as politically inflected?
Well, it's hard to figure, but I think a lot of people feel that there was an equal protection violation there. Even my good friend David Souter and Stephen Breyer were concerned about that aspect of the case, but I've never found any merit whatsoever in that view, because it basically, the equal protection rationale assumed that there was a difference from the voter's point of view between an indention that went through the, what do you call it, hanging chads and dimpled chads, as though there was a constitutional difference between the two, which is quite wrong. There's an Illinois case that's made it perfectly clear that the intention of the voter can be ascertained in both of those cases equally, and I think that was the case that I gave a talk on this subject about a year ago.
Was there discussion among the justices about the impact of this potential impact of intervening in that case altogether?
I'm not at liberty to
say.
Guess what was discussed.
Realistically, one of you asked, which of your amendments, if any, has a chance of being enacted?
Well, I know people will laugh at me when I say this. I know Judge Stephanopoulos did, but I really think in time they all make an awful lot of sense. And I think that just one of the examples that comes to mind when people say that you're being foolish to think there's a realistic possibility of this. About 10 years ago, someone would have asked about gay marriage, would have said, that's terrible, but the public opinion can change rather dramatically in a relatively short period of time if people stop and reflect and think about issues. I have confidence people can figure out what should be done.
I think that is a really interesting point about public opinion. I guess the ideal is to think that the court exists in some sort of magic zone where the political winds and even the capriciousness of public opinion doesn't affect those decisions. But there's capricious public opinion, which can bounce and bounce, and then there are broader waves of public opinion that change forever, change the notion of what is right and what is wrong. And I wonder whether and how resistant the court that you most recently sat on has been to changes in the political wind, first of all, and then I'll ask you the second question.
Well, of course, the court really does not try to, and doesn't respond to the changes in the political winds. I think the justices on the court do their best to do what they think the law requires. I mean, I gave the example of the marijuana case. I think other members of the court felt as I did, that it was not a wise statute. But the duty of a judge is to enforce the law as he or she understands its requirements. And I think the members of the court that are sitting today feel the same way. I don't think it would be correct to accuse the majority of having its own agenda. I think they are following what they think the law requires.
But when you take the issue of the broader sweep of history and public opinion, from divided on slavery to definitively against slavery to perhaps divided on segregation to definitively, against segregation, now we see a move to, there was an article today, I think, in the Times about the effort now to bring the gay marriage fight to the states in the South and the West that have been most resistant to it. Do you think responding in due course to changes in public opinion is necessarily a bad thing? Because the founders didn't intend the Constitution, just to refer to what it referred to then. I mean, it's always been an exercise in extrapolation, has it not?
Well, I suppose that's right. And I'm not sure this is exactly responsive to the question, but just in the last few days, the Washington Post had a long story about President Grant, and what a great general he was, but how he was not all that great a president. Well, since I've been retired, I've tried to learn a little more about Reconstruction in the period, and I really think that there's a huge misunderstanding of what history really was like during the period immediately after the Civil War. Grant was a fine leader in many ways that are ignored. He's the one who was responsible for the adoption of the 15th Amendment. He's the one who was supported the
who here remembers the 15th Amendment?
Right. Yeah.
Okay, because I'm
the
embarrassed.
Ku Klux Klan Act.
What?
The Ku Klux Klan Act, which was fighting the opportunity of the Klan to dominate the voting in the southern states. And people have assumed that the Republicans who were elected immediately after the Civil War were incompetent, corrupt, and so forth, and the Margaret Mitchell version of Gone with the Wind was the true story of the South. But in fact, there's a great misunderstanding of how in fact there was the resistance after the Civil War to those who were trying to allow blacks to vote and so forth, colored the entire our history for about 100 years, and it's based on really an incorrect understanding of the forces that were fighting each other at the time. And well, this is not exactly about the book, I guess.
No, but it's fascinating, and and it has to do with how flexible our institutions are, and, how both flexible and also how true to the original ideas they are able to be. I mean, it's two different forces, sometimes working together and sometimes in opposition. Did you ever feel buffeted by those winds when, in any of those 35 years you served as an associate justice?
But the point I'm not making it very well. But I think there sometimes is a very broad misunderstanding of certain very important historical events. And I do think that the period of Reconstruction is not as well understood as it should have been, because the impact on the whole southern part of the country was really much more serious than people realize.
Mm-hmm. I'm going to ask just a couple more here. Well, the Supreme Court, a lot of these are, the reason why I'm going through them like this is some of them are framed in ways that are highly inflected. And I'm trying to get to the pure nut of the question. What do you think if the country did away with electoral districts and elected representatives through proportional representation? I mean, would that be you spend a lot of time in your book about what you think is an inflated importance given to states' rights. I guess this would be the ultimate expression of rule of the majority.
Well, whether every state should have representatives on a proportional...
Mm-hmm. They didn't have districts. In other words...
Do everything at large, and I don't know.
Yeah, fair enough, fair enough.
I know it's clear, and this was part of the source of the error in the gerrymandering chapter. Justice White definitely took the view that there was no requirement of proportional representation, and I think he's right. I don't think that such a requirement is a part of our law. Whether we should amend the Constitution to make it a requirement is an entirely different question. But I don't think you have to go that far if you just get rid of gerrymandering.
One of the people here would like to know whether or not during your tenure your position on affirmative action evolved or changed in any way.
Well, it's very interesting, and it's raised by the recent case. It's not really an affirmative action case.
Everybody knows this case, right? In higher education.
It's a case involving whether Michigan could have a constitutional amendment prohibiting affirmative action in higher education. And the debate in the case, interesting, is not about the merits of affirmative action, but it's about the method by which Michigan reached its conclusion, and whether they, in effect, violated the rule against adopting laws that disadvantage minority groups when you've had a period of advantage to the minority. Changing the rule is changing the method of making the decision. But the very interesting and ironic point of the case is that I have always thought, and I wrote an opinion in the Bakke case years and years ago, that the Federal Civil Rights Act was colorblind. And I think that the fair interpretation of the legislation that was in effect back at that time would have required colorblind policies in state educational institutions. And if that was the court decided otherwise. They decided that affirmative action was permissible. But if the federal government could reach that rule, I suppose the state could also reach the same rule. But the other thing about affirmative action I will mention is that instead of, and back in those years, the primary emphasis has been trying to create a remedy for the past wrongs that had been done to the minority races. And I learned in a case called Wigand against Jackson, it dawned on me that the real objective of your rules should be the future, to try and craft your rules in a way that would help the future, and affirmative action can play a role in that. That's having integrated police forces in segregated neighborhoods, for example, made a lot of sense. But the way the law developed, the concentration seemed always on trying to make up for the harms that had been done in the past, rather than to achieve the benefits that are attainable through integration and diverse policy. And I think if they focus on the benefits for the future, that there would be stronger support for affirmative action than there has totally been.
Did you read any of Sonia Sotomayor's
yes, she wrote
dissent?
a very excellent dissent.
It was a blistering dissent.
Yeah. The only thing that I would criticize about her dissent is that she implies or gives the reader the impression that she was a beneficiary of affirmative action. But she was either the valedictorian or the salutatorian at Princeton, or the Princeton University, yes. And she didn't need any help whatsoever in her own case, even though she gave the impression she did.
I think that, she needed money. She needed financial aid. I mean, there were plenty of ways that she could have benefited. I mean, it's actually, and I know that we've run out of time, but it doesn't mean you're not as good as the non-minority candidate, and you're getting necessarily cut some slack. It could mean simply, these affirmative action is to make sure that this person gets in there and has the support to follow it through, right?
That's right. No, she wrote a very, very powerful opinion. There's no doubt about it. She does good work. No doubt about it.
And you still think it's bad to burn a flag? That it should be protected? Well,
nobody burns flags anymore.
Yeah.
When's the last flag burning you can remember?
I can't even remember any bra burnings.
It's really important to be able to do it, though, isn't it?
Well, but you think not, right? You said that it should be, as a symbol, it should be, given more.
It's very interesting. In the opinion you decided a moment ago, there's a phrase referring to that case, saying that we held that you could not punish someone who burned a flag because you disagreed with the ideas expressed by that conduct. But that's not what the case held at all. It was the conduct that was prohibited.
Right, but the conduct wasn't that they accidentally set fire to somebody's garden. You know, it was
not
hard
an
for me to
accident.
separate. That decision was a little tricky.
Well, anyway,
But I could stay here forever. You have been such a pleasure and so gracious, and thank you so much.
thank you.
Please, everybody, I'm sorry. Everybody stay seated while the justice leaves. It's a safety thing.
Okay.
Sorry.